we do have one more matter to take up before the jury comes back. Our position is that based on Special Agent Sechrist's responses under cross-examination on Friday and based on his direct examination, we believe at this point the taking of the polygraph by Mr. Bryan, which was discussed on May 13th, I believe early in the interview process, not the results of the polygraph itself, but the fact that the polygraph was taken at this point is admissible in this case, consistent with the authorities I think that we already provided to the court. The state has gone to unprecedented lengths, in my recollection, to have this witness, both in direct response to questions and on his own, try to characterize his opinion of Mr. Bryan's statements and demeanor, try and basically give his opinion as to whether the defendant has been truthful or not. And it is relevant under those circumstances that at the time that Mr. Bryan is speaking to him, that he has furnished the GBI with a polygraph. They have had the results, they've had a chance to review them, and they color the demeanor and conduct of Mr. Bryan for the rest of that interview.
Your Honor, Georgia law is clear that polygraphs are inadmissible unless, of course, we agree to it, and here we haven't agreed to it. I don't believe that anything that the state brought out makes the fact that he took a polygraph relevant. So I never asked Agent Sechrist about, his opinion as to Mr. Bryan's credibility, so I'm not sure where Mr. Gough is getting that from, but in any event, Judge, we would object to that.
First of all, Your Honor, we didn't ask to admit the polygraph results. The case law is clear, however, that circumstances involving a polygraph are sometimes relevant and admissible before the jury as opposed to the results themselves being admissible. Second, and I am somewhat confused because the state has essentially said in their opening statement everything that's in the polygraph results. The state has, I believe, acknowledged that Mr. Bryan was unarmed. They've acknowledged that he wasn't in communication. These are, in fact, the subjects of the polygraph examination. So if the state is contending that the polygraph results, even if they came in, could somehow be prejudicial, the state is not contesting or disputing any of the findings of the polygraph examination. So there could not possibly be any prejudice even if the results came out. But that's not what we're asking for. But we do think the jury needs to know that when he's talking about Mr. Bryan and his conduct on the 13th, that that's informed by the fact that he had taken and passed a polygraph on those issues.
All right, the court reviewed the authority. First of all, the court made a pretrial ruling and a motion to eliminate that the polygraph was not to be admitted. The court has also reviewed the authority provided by the defendant. That would include the Stack case, the White case, and was it Norman, I believe. And that authority does not support the admission of the taking of the lie detector under the circumstances of this case. So I guess it would be couched in a motion. That motion is denied.